priorities and try to look into it again. There's an echo. Turn it off, you mean? Okay, I'll mute myself. Oh, that didn't use. So leave studio. Okay. Hello? Okay. I'm just trying to see where my screen is down. Okay. All right, guys. I promised that was the last interruption. Difference. So they're going to give difference to previously approved cases. This is been a policy of theirs. They've been talking about it for a while, but not all officers implement it when they should be. So by putting it in the regulation, they're ensuring that everybody implements it. They've updated the definition of specialty occupation. This is a good thing. They have expanded the definition. Previously, the definition was that if your job requires a bachelor's degree in a specific field, then it's a specialty occupation. But they've increased that to a range of degree fields instead of saying specific field, which means that if the job now requires, it doesn't have to require a specific degree, but it can require a range of degrees as long as that range of degrees are related to your job. Just to give you an example, I always give the example of IT-related jobs because those are the most prevalent. So in the example of a systems analyst, for example, the Occupational Outlook Handbook, which is the document that the USCIS looks at to see what the industry standard is for a particular job, and that's OH, available online for anyone to see. If the OH says for a systems analyst, a bachelor's degree in engineering, math, physics, computer science is required. Previously, you couldn't file a H1 for a systems analyst because it is not considered to be a specialty occupation. Now, as long as you can show that those fields are all related to your job, you can file a H1 for a systems analyst. So by broadening the scope of the definition, they have increased the number of jobs that qualify to file a H1, in short, right? So that's a big deal. And this is talked about in the past also, so it's not new. It's been litigated with reference to specific degree. Should it be specific degree? Why can't it be multiple degrees? So now they've actually, in a positive way, included it in the regulations, so officers can't deny cases saying that, it's not a specific degree. They expanded the definition of exempt employers. So if you're cap exempt, certain employers are cap exempt. You don't have to be under the lottery. You don't have to file under the lottery. So the definition, especially for nonprofit research organizations and government research organizations, instead of saying that it has to be replacing the term primarily engaged in research facility, they've just said that it has to be a fundamental activity. So it doesn't have to be the only activity, but it has to be an important activity for that organization. So by that, conceivably, they're expanding the number of companies that are cap exempt. Next slide. Bona fide position requirement. This is something that they're bringing back. As of 2020, there was an ITServe versus Cessna case, which ITServe won, based on which USCIS was not asking consulting companies for contracts and work orders or proof that they have work for that particular consultant. They also require that proof if you're not a consulting company, but it seemed to be more prevalent among consulting companies. They were asking more in RFEs, mainly for consulting companies. They were asking for work orders, contracts, etc., to show that you had specialty occupation work. So they have brought that back by way of regulation in order to show that you have specialty occupation work, to show that your work is not speculative. They didn't use the word speculative, though they could. They consciously basically are saying bona fide position requirement. So in order to show that you have work for a systems analyst, for example, in the example that I gave you, you have to get a work order from your client if the person is working at a third party site, or a contract or a purchase order, um, to show that you have work available. So we're back to USCIS asking for contracts. This, of course, could be litigated because, as per the IT Serve versus Cessna lawsuit, the judge looked at the statute. He didn't look at the regulation. He looked at the statute, and the judge said, it doesn't say anywhere in the statute that you have to show proof of specialty occupation work. So we could go back, take this regulation back to court and say that, look, as per this precedent decision, you cannot ask for this because the judge agreed that it doesn't say in the statute that, you have to require proof of work. So the other change that was made is with reference to site visits. USCIS retains the authority to conduct site visits. They do this through independent consultants, usually through, they're called FTNS visits. And after your H1 gets approved, your company can be visited to make sure that the person is working at that place, or if they're working from home, they can make visits at the home, or they can make visits at the end client site if that's where they're working, depending on where they're working as per the LCA. Now they're making this site visit mandatory, meaning that you have to allow the officer into your premises, into your office, or your home, or wherever it might be. And if you don't, then they have every right to deny the case just based on the fact that you didn't cooperate with the officer. So they've put that in the regulation. They've made it compulsory. Earlier, it was already compulsory to the extent that if you didn't allow the officer home, they would write a bad report, and then they could send a notice of intent to revoke because, based on that. So they're pretty much doing the same thing, but they're putting it in the regulation. This is a very interesting thing. The next one, self-sponsoring for H1B owners. So earlier you had to have an employer, and the employer could not be related to you, and you could not have a share in that company if there had to be a clear employer-employee relationship to be able to file a H1. So most entrepreneurs could not file a H1 through their own company. Now you can, and this is a very, very interesting and path-breaking regulation that can help a lot of entrepreneurs. They've also said that even if you own more than 50% of the company, even if you're managing the company, as long as you're showing that you're spending more than 50% of the time doing your specialty occupation work, even if you're spending some time managing, it doesn't matter. You can still qualify for the H1. But they put some restrictions on it, that the H1 will be given for a period of 18 months. And then I believe you get another extension for 18 months. And then you'll get, your regular extensions on your H1. But remember, this doesn't change anything with reference to green cards. To get a green card, you still cannot sponsor yourself if you're doing this through employment EB2 or EB3 category. So you'll still then need an employer to sponsor you, because your H1 won't go on forever. 6 years is the limit for H1, so you'll have to get an I-140 approved, so you'll have to do that through another company then. So that's going to be tricky as to how people will then manage that. The next point, regulation, is about maintenance of status. On and off, USCIS always asks for documents related to maintenance of status if you're filing a change of status or a transfer, if you're presently in the US in a different status, or even if you're filing an extension, they want to make sure that you've maintained your previous H1 status. So now they're saying that you have to submit all documentation related to status upfront, and they're going to ask for much more documentation than they used to. Before, it was just two pay stubs if you're presently on a H1 and your present status to show that you're present I-94. Now I think they will ask for status from the time that you entered into the US. Might ask for all the W-2s, all the pay stubs. We have to see how that plays out. So that's interesting to see how that plays out with reference to what kind of vetting they will do and what kind of documentation they will require. Will they need all the W-2s? If you've been here for 10 years, do we have to submit 10 years W-2s? And then will they cross-check that as per, with your LCA to see whether will they want copies of your LCA, or do they already have them? Will they cross-check that to see whether you've been paid the prevailing wage? So this only time will tell as we start filing cases. So January is going to be a fun time for everyone concerned. Next slide. They've revised the cap rules for F1 students. Earlier, you could be on a cap status only until October 1st. Now they have increased that cap status until the next year, April 1st. So you would most probably won't have to file for an extension of your F1 status 99% of the time, because your H1B will be approved uh, by at least April of the next year, because doesn't take a year to get a H1B approved, right? So that's how they're making sure that you don't have to file for interim status if your H1 is not getting approved by October 1st, which presently a lot of people have to file extensions on their F1s because the H1 doesn't always get approved by October 1st. So that's the that's the H1B final rule. Let's go into the actual topic. You can, yeah. Definitely, and I'll try to go through the slides quicker in case we have a lot of questions. Yeah. So we wanted to talk about family-based immigration. I thought we should go through the visa bulletin first for January, because this is again another hot topic. So diving right in, employment-based categories, dates for filing, there's no change at all, final action date. There is advancement for India and other countries in the EB2 and EB3 category. Next slide. EB2, we see India advances by 2 months, China by 1 month, and all other countries by 2 weeks. For EB3, India advances by 3 weeks, China by 2 months, and all other countries by 2 weeks. For EB3 other workers, that is, if you are an EB3 without a bachelor's degree, India advances by 3 weeks, and all other countries except China advance by 1 week. So you see there's a few months to a few weeks advancement in EB2 and EB3 categories. Next slide. And we don't see any advancement in EB1 categories. For the family-based, F1, there's again movement, which is good. Unmarried sons and daughters of US citizens, Philippines moved up by a week, and India, China, and worldwide moved up by a month. Any movement is significant because there's usually not much movement in these categories. Spouses and children of permanent residents, this is also key. A lot of people use this category. Mexico moves up by 1 month. Within this, there's F2B, that is unmarried sons and daughters of green card holders who are 21 years or older, so adults. India and China and worldwide move up by 3 weeks. So there's a 3 week movement for F2B and a 1 month movement for Mexico for F2A. F3 married sons and daughters of US citizens. Mexico moves up by 1 month, Philippines by 2 months, and all other countries move up by 2 months. So there is overall forward movement for the F3 category. Next slide. F4 category, which is brothers and sisters of US citizens, this is the most backlogged. You see India is on 2008, 2000, yeah, and Philippines is 2004. So you see that there's a huge backlog with the F4. And so India moved up by 1 month, which is significant because there's not much forward movement in this category. Um, and Philippines moved up by 2004. So you see the forward movement, and that's 2006, sorry. For dates for filing for F2B unmarried sons and daughters 21 years and older, Mexico moved up by 3 months, F3, India and China, and worldwide moved up by 3 months, pretty significant married sons and daughters of US citizens. And F4, brothers and sisters of US citizens. Why do we have this again? I think this is just a repeat. Oh, this is dates for filing. Sorry, guys. That was final action date. And this table, which I'm talking about, is dates for filing. So you will see a difference. F2B, again, same categories, but this is the dates for filing table. This is where you're allowed to file in advance. And your priority date is not actually available, but you get to file in advance and you get the benefit of being in a pending 485 status and having advance parole and EAD, etc. So again, F2B, we go through the same categories, but the dates have advanced more in the dates for filing. 3 months for unmarried sons and daughters. F3, married sons and daughters, 3 months again. Brothers and sisters of US citizens, that's 2 weeks compared to 1 month for the final action dates. We can go to the next slide. Um, I'm just wondering, how do I exit the, if I'm on full screen? Okay, I'll figure it out. Don't worry, Michelle. Okay, so what changes do we expect in the family-based immigration with under Trump? Right, this is the key question that we are going to talk about today. We can expect a general tightening of family-based immigration, which basically means that we can expect that there will be delay, deny. You know, this is the way that you tighten immigration if you're not trying to change the law. There will be delay in processing, maybe more vetting and therefore more denials, more request for documents. So and we might also see some some priority shifts in policy. So immediate family members might still remain a priority. I mean, may not change, but extended family members, like we talked about, F2, F2B, and F3, and F1, and all those different categories that we were talking about. Immediate relative are basically if you are a US citizen petitioner and you're sponsoring your immediate relatives, which is parents, children, or spouses. So that we don't expect change. But last time the Trump administration did try to do away with the other family-based categories. So let's see whether they're able to do that now or whether they even try to do it or not. So as I said, extended family members, they might see some changes, but we have to wait and see. Next slide. As I was saying, stricter scrutiny and increase in processing times, increased in the vetting process. So they might bring in new requirements like they brought in the public charge rule during the Trump administration, and that really slowed down the process and resulted in denials until it was actually taken to court. Um, Significant backlogs we saw under the Trump administration. There were a lot of USCIS officers laid off and they were not rehired. So they were short staffed, and that was not really a priority to staff USCIS properly. So that caused delays, which was, I think, intentional. So a delay is as good as a deny, right? Delaying a benefit is as good as not giving a benefit, and that's how they were operating. Let's see what happens this time. Next slide. How will this affect you if you plan to sponsor a family member? You have to understand what the policy changes are and what the impacts might be on you. Um, so if you're sponsoring immediate relatives, most probably you'll have longer wait times and extra scrutiny maybe. But if you're sponsoring extended family members, maybe you should file as soon as possible because they might. I'm not saying they will, but they did try to do away with it. It's difficult to do that, to change the law because that will require legislative approval, and they do have uh, majority in both the House and Senate, at least for the next 2 years. So whether they'll do it or not, it depends on their priorities. So that is slightly at risk, extended family members. Next slide. For cases that are already pending, how will this affect you? Again, stay updated on any of the rules. Some rules are sometimes made retroactive. So make sure that if there's any new rule that comes into place, that it's not retroactive, and try to talk to your attorney to find out whether it affects you or not. Monitor your progress. Make sure you submit a complete application, um, and quickly address any RFEs that you have so that you can get your approval before any such changes happen. So that's what you should do. Next slide. As I was saying, submit your documentation earlier. Provide accurate information. Fill out your forms properly. Document all your case properly. Send out those birth certificates. Send out the non-availability certificate. Send out the financial evidence. So prepare a complete application and don't send out your medicals. Now medicals are compulsory anyway. That's the new another update that I have for you. You can no longer send out your application without a medical. You have to have a medical to send out your application. Otherwise, USCIS will send the entire case back. So earlier, people would send out their application without medicals because they would want to send them out quickly, and they would be worried that their priority dates would retrogress because sometimes priority dates only remain for a month. And medicals take time, especially if everyone is applying at the same time, right? If dates suddenly jump forward, then there's no time to get medicals done because that itself takes a month sometimes. So anyway, but now you can't do that. You have to submit medicals along with your application. So, and anyway, it makes sense to send out a complete application because you want this to be approved or processed or looked at as soon as possible, especially if your priority date is current, rather than waiting for the new administration to come in and pass some new rules which might then affect your application. Next slide. As I was saying, again, consult an expert, get an attorney to work on your case so that there's no gaps in your petition. Sometimes you might review it the best that you can, but you may not know of a document that has to be submitted or what the document has to look like. So rather than getting an RFE and delaying your case further, I would suggest that you work with an expert in getting your application filed, so that you know exactly what documentation to submit, what, proof of relationship documentation, financial documentation. Um, if you're filing for a spouse case, to show that it's a bona fide marriage and is not a sham marriage, there's certain documentation that has to be submitted. So, submit all that documentation ahead of time. Don't wait for your interview or don't wait for an RFE to do that. Next slide. So I just wanted to go through quickly what the different changes were under the Trump administration, then what happened under the Biden administration, and then what to expect, going forward. And this is only with reference to family-based petitions, right? So the big thing is the public charge rule. The Trump administration introduced a stricter requirement for proving financial stability. So public charge rule basically is uh, they want to make sure that you are not a public charge once you get a green card. So if they think that you might become a public charge, or they think that you're already a public charge because you've already taken certain benefits, then that's a reason to deny your application. Under the Trump administration, they made um, the um, scope of public charge a little broader, and they expanded the criteria that they use to determine whether an immigrant, whether a non-immigrant seeking an immigrant petition could be considered a public charge or not. So under this new rule, immigrants who are deemed likely to rely on certain public benefits um, could be denied admission, or um, or denied a green card, even if you're in the country. So how did they do that? They expanded the definition of public charge. Traditionally, public charge referred to an immigrant who is depending on government assistance for their survival. That is just institutionalization, long-term institutionalization at the expense of the government, or if you are on some kind of an SSI, meaning you are taking money from the government for support. So under Trump administration, they included everything else: Medicaid, food stamps, housing assistance. If you took assistance as because you were pregnant or your child took assistance, there were some exceptions, of course, and that was one of them, I think. But everything that you took, food stamps, everything was included. Where traditionally, under the public charge criteria, that was not included before. It was just long-term institutionalization and SSI, meaning if you took supplemental security income. But they included a whole lot of other things. Emergency medical services, school lunches, right? So if you go to a public school, they'll give you free lunch. So if you took up that free lunch, that also was included as a criteria to deny your case um, under the public charge rule. They also used this totality of circumstances rule under the Trump administration, where they said that in order to test whether you would be a public charge or not, they looked at other factors as well, such as age, your health, your family size, your financial resources, education, your skills. And then they could make a determination based on that. And it would often be subjective, right? Because the officers are being given some broad factors, but they could always made within that. They could always make a determination subjectively that you don't qualify. So this was brought about a lot of anxiety among um, many applicants because they didn't know, it was uncertainty that whether their case will get approved or not. So the reason I'm going through so much detail of what the previous administration did was because that's more of the same that we can expect next year. That's why it's important to see what the history is to know what to expect in the following year. Also, applicants who had an income below the poverty line um, or had used certain public benefits for more than 12 months in the past 3 years were likely to be considered a public charge. So even if they now um, are not using any benefits, but in the past they used benefits in the last 1 year, and if they were below that 125% of the poverty line, then they could be affected also. As I said, there were some exemptions under the old law, such as people who were seeking refugee or asylum status, or children or pregnant women who took Medicaid, they were exempt. How did this affect the entire process? It had a chilling effect on many immigrant communities, not just the immigration process, but on immigration communities themselves. They feared negative consequences of taking any kind of public benefit. And so often they did not, even though they needed it, such as healthcare, food assistance, housing. And it, of course, disproportionately affected low income people, especially from the minority communities. So there was an imbalance there. So poorer people were affected more than richer people were, right? And that's not how the law is supposed to be. But of course, there were legal challenges to this public charge rule. And in 2021, under the Biden administration, the rule was officially repealed. Before that, it was blocked by the courts and then finally repealed by the Biden administration. Um, so, yes, that's a little bit about public charge, and that is something that really affected the entire process of family-based immigration. They also mandated, they had mandatory adjustment interviews right now under the Biden administration, and even before that, prior to Trump's previous term, not all green card cases were interviewed. They were interviewed on a case-by-case basis. I must say, under the present administration, there are very few interviews. Family-based cases also are not being interviewed, and in fact, not all spouse cases are interviewed. Previously, spouse cases, because they're considered to be, sham marriages until proven otherwise. You have to show that it's a bona fide marriage. So all spouse cases are traditionally interviewed, but now I've noticed that even spouse cases, not all cases are being interviewed. They're being interviewed on a case-by-case basis. Moving forward, we can expect that there will be again a mandatory interview process. Uh, about this, in order to file a family-based petition, you have to file an affidavit of support. You have to show that your income is above the poverty guidelines, 125% above the poverty guideline. And in order to show that, you'd have to fill out that affidavit of support form and submit your tax returns. So under the Trump administration, they tried to increase um, the affidavit of support poverty guidelines. They did not quite do it, but there was proposals to increase the poverty guidelines because they wanted to give benefits to wealthier immigrants, and they did not want poorer immigrants in the country. So everything they did was focused towards, helping wealthier people stay in the country while discouraging poorer people from staying in the country. So, and that was also the public charge rule also was done in that way. And now you can expect more of the same. They didn't get a chance to do that last time, but they might increase the minimum income requirements for you to be able to sponsor your immediate relative or your extended family member. Next slide. They introduced a new form called the I-944. This was a lengthy form that required a lot of information being submitted. It was called the Declaration of Self-Sufficiency form. And under this form, it was required to prove that you're self-sufficient. This was going beyond public charge. You had to actually show that you're self-sufficient and unlikely to rely on any public benefits going forward. But they made this so cumbersome. There was a whole lot of questions that had to be answered, right, from your health to your education to your skills level. And also, there was I remember during 2020 when we had a deadline, when the priority dates became available for employment-based cases I'm talking about, we had to submit literally thousands of documents of financial documents because that was required under the 944 form. So we submitted 3 years of tax returns, bank account statements, evidence of property such as stocks, bonds, your entire share portfolio, your mortgage, if you had any credit card debts, loans, degree copies, health insurance, life insurance. Um, if you ever used any benefits, then proof of that. And this was an increased burden. There were Like each application was thousands of pages long. So this increased the burden on applicants because collecting all this financial data was really difficult, and it had a chilling effect because, as I said, people stopped applying for benefits because they were scared that if they filed for benefits, they wouldn't get a green card. Delayed processing and shifted eligibility to higher income people and limited the eligibility of lower income people. So luckily, this was discontinued uh, under Biden. And again, multiple lawsuits were filed. And so, do we expect it back? Yes, we do. Let's wait and see what happens. But this is, a picture of the past shows us what might happen in the future. And since it's the same person who's running, who's going to be president, and he has the same people advising him, uh, you know, many of the same people, like Steve Bannon and Holmes, etc., advising him, that we can expect some of this to happen again. Next slide. So we talked about the affidavit of support requirements. For fiance visas, they increased the denial rates, asked for additional documentation. So they've made it much more difficult for your fiance to get a green card if you're not actually married, but you're calling your fiance to the US and then you get married here within 90 days. That's called the K-1 fiance visa. Now, under the Biden administration, they've streamlined this process. Denial rates have been reduced. They're likely to introduce higher evidence thresholds, leading to more denials under the Trump administration. Uh, Mixed status families, they made it harder for families with undocumented members to apply for certain benefits, um, simply because they were afraid that the other family members might get affected. So they've kind of made it more difficult for family members who had illegal aliens living with them to apply for any benefits or even apply for a green card because everything was being scrutinized. So, that's something that might happen again if there are mixed families, people, some who are legal, some who are not legal, not having any immigration status, that could impact those families, of course. And again, waivers. Um, Waivers are basically you want to file a green card, but you're ineligible due to some conditions. Maybe you've previously have out of status period, or you committed some fraud, or there's some you didn't follow the law, and you've committed a criminal offense. You can still file for a waiver under certain circumstances, very strict and narrow circumstances, and then file for the green card and be united with your family members, your wife, your children. um, Waivers are being streamlined now and more simplified, but still difficult to get. Under the Trump administration, it was really, really difficult and time consuming to get any kind of waiver. Next slide. Um, Also, we have to remember I'm just going to mention this very briefly, and I'm not going to go through the other slides, so I want to leave time for questions. There was something called the RAISE Act introduced during the last term of Trump. And this was done by Senator Tom Cotton and David Perdue. They wanted to reduce legal immigration by 50%, focus on merit-based immigration rather than family. So they wanted to do away with family-based immigration completely and just follow a point-wise system where no points were given for immediate relatives. Next slide. So this, I'm just talking about some legislation, the possibility of some legislation being introduced to make some permanent changes in the immigration process. So as I said, the RAISE Act wanted to eliminate family-based visa categories and the diversity visa lottery. They have a visa now, 50,000 visas, green cards for people underrepresented countries. So that's the visa lottery process. They wanted to do away with that. And they wanted to cap for the number of refugees coming to the country to 50,000. Next slide. And the merit-based system, they wanted it based on education, age, English proficiency, what job do you have, how much money you have. Again, you know, encouraging rich people and, you know, sidelining the poor. Next. So yeah, that's it. I think let's go to questions now. We don't have to get into how to file a green card and all that. We can leave that to another session. Maybe put up the Q&A slide. Yeah. Oh, you wanted to do this? You wanted to do that? Okay. Yeah. Okay. Yes. So if you have a US citizen daughter who's over 21, she will be able to sponsor you. But as you said, she needs to come back to the US and establish residency here if she's in Canada in order to sponsor you. And even if she doesn't have the ability to sponsor you financially, she can get an affidavit of support from another family member, so they can co-sponsor you from the financial point of view. So you can have another family member fill out the affidavit of support along with her, and that way you can take care of that issue with reference to having enough money to be able to, you know, fill out that affidavit of support, which is a requirement for the green card. And also you might want to come into the US first, um, and establish residence and then file for adjustment. There are two ways of doing it. One is come here and then file for adjustment. That's faster, because you can file an I-130 and 485 together. Or if you're outside the country, then you just have to file an I-130. It might take a couple of years for you to um, get the immigrant visa approved through NVC and then through the consulate in Canada. You'll have an interview there, and then you'll be able to come in on a green card, you know, out from Canada. But you'll have to wait for a couple of years after filing it. When you're renewing your green card, they call you in for biometrics and they take your photo and fingerprints. So they'll do it for you. Yeah. Do you have it? Is it written in the chat somewhere so I can read it or no? Yeah, I think we can just, so that even for people following, it's just easier for them to read the question. especially if it's a long question. Is it in the chat? Q&A. Okay. So basically, my husband did a, this person is saying, Nishan, no, this person is saying my husband did H1B transfer while I was in India. On my return to USA, I had old visa stamped valid till March 2025, and my husband new 7 valid till I don't understand. I got I-94 until then a certain date. My question is, do I need to do H4 transfer? My H4 EAD expiring. Can I extend it? I need to do H4 and H4 EAD transfer. I don't know how it is a transfer. Basically, she's saying that since my husband filed a transfer to another company, does my H4 still hold good? Or do I also have to do some kind of a H4 transfer? Is I think what she's saying. No, every time your husband files for a H1, you do not have to file for any kind of a H4 transfer. Your H4 remains as long as it's valid, and you have validity till 2027, as you said. So if your EAD continues to be valid and your I-94 continues to be valid, you're good. You don't have to do anything, and you can travel using that I-94 as well. Yeah, absolutely. Yes. F2A is spouse and child of a permanent resident. And usually, the F2As are not, they've often been current. So I'm surprised that the F2As are not doing that well. But yeah, it is pretty frustrating. I understand that. But there are chances of F2As becoming current, especially worldwide, uh, because from the last few years it has been, even for Indian nationals it has been current. So forget about other countries. So I think there's a good chance of forward movement in F2A this year. No, there is no rule against husband and wife working at the same company, which is what it is in this case, right? So I don't see any issue as long as you're able to show that you have a valid bona fide job offer, and I mean, if you're going for a visa soon, anytime after January 20th, most probably they'll ask for the client letter and a lot of other documentation. So as long as you're able to provide that, I don't think the fact that both of you work for the same company by itself is an issue. There's no option, there's no problem with getting married after the L1 gets approved. because in the L1 petition anyway, you're not putting your spouse's name. The spouse can just accompany you to the interview when you go for your L1 visa interview, along with, of course, you have to apply for her, a slot for her. You have to reserve a slot for her, and uh, pay the fee, etc. But as long as you take the relationship documents to show without any doubt that she is your spouse, you can both attend the interview at the same time, and she can get the L2 visa stamped in her passport at the same time that you do. See, it might take some time for NVC to send you an email, but once they do update it, they will send you an email, and then they will ask you to fill out the forms, pay the fee. First, you have to pay the fee, then fill out the forms, and then upload the documents. And everything is done on their portal online. And then once that is done and they are happy with the documentation and information that you've submitted, they will forward that to the consulate. And then the consulate will call you for an appointment and issue you an immigrant visa there. And then, you come in with the immigrant visa, and then you get the green card in the mail once you come in. But what is the time period? Since it's only August 2024, it's difficult to say exactly when, but usually they take a few months. And again, it's case by case, it differs from case to case. But I wouldn't be overly worried that you have not yet been notified by NVC because they have a backlog. Thank you.